We'll now resume proceedings of Finance Committee. Please be seated. When we took the break, we were discussing matters at the Cayman Islands Airports Authority, and I had asked for there to be some restraint in the line of questioning, and we will now continue, and hopefully we will be able to get through this matter fairly quickly. Mr. Bush.
Mr. Bush, thank you, Mr. Chairman. Mr. Chairman, I asked a while ago, and I'm trying to get to the bottom of how the reinstatement took place. I believe that Mr. Bothwell ought to rethink about the matter of what happened with the hard drives, because basically I was asking about one hard drive and he referred to another hard drive. I asked Mr. Mr. Bothwell, how did he get instructions to conclude the disciplinary matters? And that's what I want some clarity on.
Mr. Bothwell.
Thank you, Mr. Chairman. I was given instructions from the acting CEO to conduct an investigation into that matter to conclude it. And that's all I did. They found disciplinary items that we actioned. Discipline was given and the matter was closed. The gentleman couldn't be reinstated because he was never, he was just on suspension.
Okay, you said, I call it reinstatement, but anyway, when the staff member was brought back to work, you received instructions from the acting CEO. Where did he get his instructions?
I don't know, so I would have to assume when, because that was shortly after the change of acting CEOs. I'm still not clear on this, because you had a discussion with the staff member that was suspended. Correct, as a part of the investigation, his...
And when you spoke to him, you told him what?
I told him, I said that I've been instructed to do an investigation.
You wrote to him or verbally?
Verbally.
You didn't write to him?
No, sir, he wouldn't have had an account with us.
Before you leave, before you get to that, correspondence is on the 16th of December to Julian Watler from Sheen Bothwell, subject conclusion of disciplinary matters. You wrote that?
It was after the fact, correct.
And you says, I was instructed by the board of directors to bring your disciplinary matters to a conclusion.
Correct. So what happened is the acting CEO gave me instructions. I went ahead and did it because the acting CEO was a witness during the initial interview, whatever, for that same matter with the IT manager. He couldn't actually do it. So the authority was delegated to me by the board because the acting CEO couldn't do it because he was party to the matter.
So the board instructed you. That's what you just said.
Correct, to conclude the matter because the investigation was done.
What I'm trying to determine, Mr. Chairman, is how could the board, who is not into management affairs, direct anyone to bring any such disciplinary matter to a head?
I think what Mr. Bush is saying is that there's some missing link. I think what he's asking is who then took it to the board, that they would then ask you or authorize you to bring the matter to a close. If I understand where he's going, I think that is what he's asking, but he can clarify that if I am wrong.
Could I just make a clarification?
Yeah.
This goes on the file.
Yeah, it's going to be flat.
Mr. Chairman, through you, sir, I would like to say again, the board did not deal with this matter. We appointed the acting CEO, and his authority comes from that appointment. But the actual action, the board doesn't get involved in. I don't know any more about this case than what Mr. Bush seems to have more than we know about it. Because we deliberately do not get involved with staff matters. And that's a fact. Okay? We just would like to make it quite clear. Yes.
Mr. Miller?
Through you, Mr. Chairman, the board chairman is saying the board did not get involved, that the acting CEO had the authority under the normal, the reconsideration of the matter as to whether the person was suspended would have come from the second acting CEO.
Yes,
not from the board.
And he devolved his authority from that appointment to deal with that and all other sort of matters that the CEO was dealing with, right? So the involvement of the board, as I understand it, is to give him that authority to deal with it and leave him to make the decision of what's right or wrong or whatever. But I can state categorically, for the record, the board had no input into this matter. And I would like to make that clear because there's a lot of misinformation being put out there about the board responsible for this, the board is responsible for that. The board is dealing with policy and strategic matters, and that's what we do. And that's why we have a CEO to deal with the day-to-day management of the airport.
So, Mr. Chairman, when Mr. Bothwell wrote the disciplinary findings report, and he said, I was instructed by the board of directors to bring your disciplinary matters to a conclusion. When he says that, that's not the case. In other words, what Mr. Nixon is saying is that they appointed him, and now the way he wrote it, and you can't write things to say something and then people check it to mean something else. So when Mr. Boswell wrote this, he didn't mean that he got a direct instruction, but that instruction was a broader appointment.
Mr. Bush, what's the date of the correspondence, sir?
16th of December, 2013.
Okay, thank you.
Could I just add that this is one of about 3 or 4, maybe 5 legal cases that the board has dealing with, and we need to be rather careful not to breach the legality of some of these other matters to make it clear the board role in all of this. That's all we're trying to do.
But when you say legal matter, and what issue is this other than...
These are other cases,
Yeah, but that has nothing to do with this particular matter.
except that the precedent.
No, I am not here saying that the board did, What I am asking is, what did Mr. Boswell mean when he said, I was instructed by the board of directors to bring your disciplinary matter to a conclusion?
I think perhaps, I think Mr. Nixon is clear in saying that the board had no involvement in the matter, so perhaps Mr. Bothwell should explain
Yes.
why he wrote
Yes.
the board instructed.
Thank you, Mr. Chairman. In this matter, in this specific matter only, I would have had the authority of the acting CEO. That's all it was.
And yes,
That's all.
I understand.
Nothing more than that.
No, when you wrote, I was instructed, that's what I want to find. That's what I'm trying to get clarity on. I was instructed by the board of directors. That's what you wrote.
Well, yes, sir. That was in my mind. Thought at the time was when the CEO talks to the board, they give broad instructions on what to do, nothing specific.
You had no instructions, you had no discussions with the board on this matter?
Not at that time.
Not when you wrote this on the 16th of December?
No, sir. Not at that time.
Before?
No, after.
Afterwards? After you wrote? And so what did you mean by that? That's, Mr. Chairman, I am still getting, because there is a matter of policy and there is a matter of where the management stood. So whether the management acted on their own behalf or whether they acted with somebody else say so is what I am trying to determine. I heard what Mr. Nixon has said, that the board did not give any such instruction, but yet we have the acting person in that post saying, I was instructed. And that's all I'm asking Mr. Bothwell to have clarified that. It's not clarified to me, but I'm going to leave it because the correspondence says what it says. And I don't know that Mr. Bothwell want to impugn himself anymore.
No, sir.
Yeah, right.
You want
Yes,
to
sir.
speak?
I'm sorry. Yeah, the confidential email Mr. Bush refers to was just meant that how I wrote it, just how I write all my emails. Pretty formal.
This is not an email, though, Mr. Bothwell. This is a very specific letter, written document.
It's one of the confidential documents from the investigation.
This is a pair of findings report. Here's what it says. I was instructed by the board of directors to bring your disciplinary matters to a conclusion. I gathered all the documentation concerning these matters from the HRMs, CIA, and the authorities' lawyers for this matter. I spent several days going through the documents and spoke with both other persons, or you named other person. You get some, and you to get some clarity on certain points. My decision on the matters listed from your disciplinary meetings on the 19th of September 2013 are as follows. My decision in this matter is to have the offensive data removed from the hard drive and issue an employee warning notice. To you, I further advise that an independent IT company be brought in to assess the entire IT system and with the assistance of the ISM, make recommendations so as to the best method of securing our IT-based systems along with providing examples of best practice within the industry. And it was the first warning, really, that's based, after 7 months, that's what you said he was off?
I believe, sir,
6 or 7 months. So he got a first warning on the specific case of not to do those things. But it is your letter, your document.
You were going to ask another question?
Yes, sir.
Okay.
Mr. Chairman, I hate to raise this one as well, but I must, because I want to get to the bottom of the suspension of the director, or the retirement of the director at the time. Because a lot of things are not gelling, and perhaps management can satisfy us that there was no forced retirement. Mr. Chairman, there were several letters that came out. One saying that the then director was going on vacation. Correspondence after that says that he was on not coming back to work. Maybe, I don't think that Mr. Bothwell can answer this, Mr. Chairman. Really, I think they've done him bad enough today. I don't know if the board can handle it or management.
I'll just tell you what happened, and then you can take it from there. Mr. Chairman, through you, and you know, we have to be very careful on how we deal with these personal matters in this forum. But all I am going to say about this was that when we went to the airport on appointment by the minister, there was an acting CEO. And we worked along with the individual up to a point. And then he came to me to say, look, I have some outstanding vacation. And I need to take it before the end of the year. And he said, you need to pay me for it, or I need to go. So I said, well, I can't make a decision on this. Cost, put a cost into the payment, and then how much leave you owed, and I'll take it to the board. And that's exactly what I did. The board decided that he should go on vacation. So when he went on vacation, we appointed someone else to act, which was Mr. Andrew, right? At that point, the individual was not an acting CEO. He was then whatever his substantive post was at the time. It is simple as that. He was acting, he was not the CEO. And when he went on vacation, we appointed someone else to act. And that was the board involvement in that matter. And Mr. Andrew can tell you what happened after that. Any clarification about that process?
When he was appointed by the old board as the...
I'm assuming it was the old board that appointed him as acting CEO. Right? We found him there as acting CEO, and we left him there as acting CEO the months that we worked with him until he came requesting vacation. On his request for vacation or payment, the board decided you can go on vacation because it's been a while he hadn't been on vacation. And it was a board decision, and we stand by our decision.
And the board, in his absence, although he was really the acting chief executive officer, the board then appointed somebody else while he was on vacation. Is that what you were saying,
No,
Mr.
Mr.
Nixon?
Bush, he was the acting CEO.
Chief executive officer, yes?
Exactly right.
Right.
And when you act for a time, and when you go on vacation, you demit that office, someone else acts in his place. That's all that happened.
So when he said in December that he was, or November, that he was going on vacation for the month of December until early January. And to extend to Mr. McLaughlin, who had been appointed now as acting CEO officer, effective with that date, extend to him all courtesy and cooperation. So he had known then that he was no longer the acting chief executive officer.
But he should have known, sir.
When you say he
Because
should,
we were appointing, so he was acting, he wasn't the substantive post holder. Or that's how I understand it.
for all intents and purposes, I took it that he was in that post substantively.
Oh, no. I'm sorry.
So what happened then that he was put on retirement?
Well, we advertised the job. And he had the right to apply. And we made it known from the beginning that we were looking for an executive for the job, and he would have the interview for it like everybody else. And that is exactly what happened. I think if you would like Mr. Andrew apply.
In the statement that was made by you all, because I think you all made some statement to the press to say that he was, the acting CEO was out on
He was on vacation.
yes.
Yes.
But you all said the acting CEO was on vacation. That's how it was reported.
No, we called the name and said this person was on vacation. Because the day that he went on vacation, he ceased to act.
Oh, I didn't know that how we do it, but
Well, I mean, that's how the civil service do it. I mean, I don't know what we did wrong. I thought we were following the proper protocol by doing it that way. If there anything was breached, I wish somebody would tell me.
Mr. Chairman, maybe I need to ask Mr. McLaughlin.
Well, Andrew can come and you can take over from there, maybe.
You see, Mr. Chairman, the then CEO say, I will be on vacation for the month of December until early January, commencing Monday, December 2nd, 2013. Mr. Andrew McLaughlin has been appointed acting effective that date. Please extend to him all courtesies and cooperation accordingly. And if you look at the dates, the two don't coincide. The time that he went off and they said that he was on vacation, the time that he actually said that he would not be returning. Mr. McLaughlin, there was a letter written by I guess they are the authorities' legal team. That is Rich and Conley. There was a letter which you would have known about, told the relevant to the suspended employee matter and board what was termed in that letter as board interference, which said to them section 17.1 and 17.2 of the anti-corruption law. Talked about it. It also specifically mentioned the name of the board and yourself in relation to his appointments, to your appointments as acting CEO. That letter was addressed to Mr. Nixon, board chairman, and to the then acting Mr. McCoy. I would like to get a copy of that letter. I would like this committee to get a copy of the correspondence provided, the letter written by the Rich and Conley team, author Edwin Gomez, the man that wrote the team, the lawyer. And that, I think, can clear up some of the doubts and give clarity to some of these things. You recall the letter, right?
I'm not familiar with that letter. The actual date is on my appointment letter, but I'm almost positive it was 1 December. And at that point, I called Rich and Connolly, and one of my first actions was to make sure they understood that they would only deal with the CEO of the CIA at that time, which was
There was
myself.
an early letter, Mr. McLaughlin, and there was an FOI that requested that letter, and there was a letter back to you and correspondence saying, this is what the letter says from you.
A letter from me?
Yes, to Mr. Matthew Dawes, You know who that is?
Yeah, Mr. Matthew Dorr is the representative at Rich and Connolly I was
Yes.
working with.
And you wrote to him about the request.
An email or a letter, sir?
You said on email, when I see him writing,
Okay.
whatever it was typed, please find below a very detailed and strange request for information from anonymous source unadvised.
Yes.
Now that was about that letter. And the lawyer wrote back to you, dear Andrew. You wrote to him on the 25th and he wrote to you on the 26th. The request is extremely detailed and its focus is clear. It's apparent that the author of the request possesses detailed knowledge of issues relating to the employment of the IT manager and the documents that exist. The letter of the 4th December 2013 was only sent in hard copy to the then acting, if that's what he was, and to the chairman. I have attached for your convenience a document containing the most relevant provisions of the Freedom of Information Law and the Freedom of Information Regulations. I have reviewed, because obviously the information officer was involved, I have reviewed Karen's comments and I would recommend a slightly different approach. I do not agree that seeking to narrow the scope, which she recommended, of the request as an alternative to refusing the request on the basis of Section 9, that's what she said, of the FOIA. On reasonable diversion of resources. That's what the information officer said. I think that's what she advised you.
Yes.
Regulation 10 of the FOI regs is clear that a public authority must invite consultation with a view to narrow a request before making a decision to refuse a request pursuant to Section 9C of the law. Mr. McLaughlin, this letter, and these, when I call letters, these emails are definite positive proof that a letter exists and that you have knowledge of that letter and that letter was written to the chairman and to the then acting director.
I would have to, Mr. Chairman, through you, I would have to ask for whatever proof you're holding there that says that I saw this letter, because I'm not familiar with the letter you're talking about.
Well, why?
But I am familiar with the email that I sent to Mr. Doors, and it was in relation to a Freedom of Information request. But I didn't say in that Freedom of Information request a specific letter. I was asking for advice on a large amount of information that was asked for or requested of my Freedom of Information manager at the time. There was an enormous amount of things going on, and we were running an airport working at 200% capacity at the time.
We know
while
all of
we were
that,
trying to
Mr.
comply
McLaughlin.
with freedom of information.
I hear you,
So
but there's evidence that you all had knowledge of things that you're saying you not have knowledge on, and I certainly don't appreciate that, because it says that you all had knowledge of the letter. The FOI says that. The one that you had, the one that your information officer had, the one that your lawyers advised you all not on how to proceed with it.
Yes, I'm sure someone in the CIA, 2 people received it, but I hope you're not saying that I personally had the letter in my possession.
I'm not saying that you personally had, I'm saying you have knowledge of it. And that letter exists, and that's why I want a copy of it. And I think this committee, because it would clarify a lot of things.
If the letter exists, sir,
If-
Mr. Chairman, it will be provided.
And I'm not going on if you say it don't exist, you need to say that, bearing in mind what our standing orders say. You need to say this letter do not exist. You need to say
I
that.
can't say that.
Okay.
I cannot say the letter does not exist.
But I'm not saying the letter was written to you.
Right.
I said who the letter was written to. I would like to get a copy of that letter, Mr. Chairman, because it would clarify a lot of things.
Agreed.
Mr. McLaughlin,
Yes, sir.
are you able to obtain a copy of the letter? What's the date of the letter, Mr. Bush?
Early January.
The letter was written in early January? No.
The letter from, how many letters you have from your lawyers in regards to this thing?
Many went back.
Well, the one that was written to the acting director at the time, who
That
was
was
on leave or was put on leave and then let go, whatever he was done, and the one that was to the chairman. In regards to the matter, Mr. Chairman, The one that talks about section 17.1 and 17.2 of the anti-corruption law, the one that warned you all of it.
Mr. Chairman, I'm not in possession of the letter.
Mr. Chairman, the board has to be, therefore, the board should be able to get it from you as the authorities lead man at this point, needs to be able to get that letter.
Right. Sir, the CEO of the airport is away, off island, and his office is locked. And anything,
Yeah, right.
anything that would have been in relation to this, the Freedom of Information Manager or the CEO would have possession of those documents. I don't have control of those documents at this time.
Mr. McLaughlin, we've spent a lot of time on this particular matter. I don't like it any more than anyone else does. But at the end of the day, the member does have a right to request the letter.
Yes, sir.
I realize that the CEO is on vacation,
Yeah, but somebody can get that letter.
but perhaps it is possible that someone does have a key to his office and someone does know the filing system. Mr. Nixon?
Sure.
Mr. Chairman.
If it's the same letter that I'm thinking about, I have a letter that I received from our lawyers advising us that statements were made about myself and the deputy by the acting CEO, right? And he wanted us to be aware that the statement was made. It's a privileged letter, and he asked us to respond to it, right? But as far as I know, this letter is privileged between correspondence between our lawyers and ourselves, advising us that this was said.
Is the matter being litigated? Is the matter being litigated?
If the matter is being,
Is it in the courts or?
No.
no.
Mr. Chairman, the lawyer maybe can't release it, but he can.
And I think, Mr. Chairman, that letter will clear up a lot of these things that we've been saying. And I have to agree with members that when something is not sub judice, that's the only time that this committee cannot be ruled out and say you can't have this. That's pertaining to all of this that we've been discussing since 4 o'clock or before.
Mr. Chairman, one question I need clarified, sir. Have things changed within the civil service, or are these boards, which more and more I see seem to have a life of their own? I know of the recently retired or moved on head of tourism, acted for 3 or 4 years. I know when he went on vacation, he came back, the job was there. Before I left government, I acted for 6 months. The boss had a heart attack. I acted for 6 months, came back, and I had the job was there. So has something changed that if you're acting and you go on vacation, you automatically, that's the part I didn't seem to get clear. I don't understand.
I think, Mr. Bush, the answer to your question is that both your situation and the Director of Tourism are both good departments within central government, whereas, and that would come under the Public Service Management Law, whereas the authorities would have their own guidelines and would fall under the labor law. So that may explain the difference there. Not saying that the practice should be different in terms of the internal workings, but in terms of the laws under which they govern under separate laws.
Mr. Chairman, while they're discussing that, this matter about, and that's why this letter is important, and I think I want to stress to Mr. Nixon, and I don't think I need to stress to him because Mr. Nixon has been around this scene much longer than McKeever, and been one who we all respected as a good civil servant. But when they say that this nobody had anything to do with, I'm getting tired of not really pointing out to the name because we're going around in circles, but they then Mr. McCoy, the acting director, when they said that he was on leave, did then Mr. McLaughlin, the new acting CEO, McLaughlin, released a statement, and that statement is in the press, on behalf of the CIAA, confirming that Mr. McCoy remained on leave and that he would be returning to a new post in the new year. And that's what I'm trying to determine, what's all this confusion. The significance of this are the dates do not coincide. They say one date that he's on leave, the next one, and the next statement by the acting CC, he's coming back to a new post. And then we have a statement from the same man that says, look, I am presently on pre-retirement leave until my retirement becomes effective February 14th and will be in and out of office as needed. Come on, man. You can make all these statements confusing everybody, and then I am left like, people ask me, what went on? You're the leader of the opposition. You're supposed to know these things. I don't know. I'm trying to find out. But I do have a constitutional right to know. And that letter is very important. I want the letter, Mr. Chairman. This committee should help me in demanding that that letter comes.
Mr. McLaughlin, as I was saying earlier, it appears that the letter does exist. There seems to be sufficient knowledge of the existence of this letter. I think the member has made it sufficiently clear as to which letter he's referring to. I know you've said that the CEO's office is locked, but I wouldn't think that it is locked and no one has a key. That would be highly unusual. And perhaps there is someone who may have knowledge of the filing system. So I would ask that the member's request be respected.
Mr. Chairman, Mr. Bothwell, as head of security, and he's temporary freedom of information, would be the only person that could possibly do that if he may be excused.
Mr. Chairman.
Mr. Chairman, if I can bring some clarity to this. And I've been out of it because I don't know. I don't have any information on this.
Before you start, Mr. McLean, are members willing for Mr. Bothwell to leave the chamber and go and retrieve a copy of the letter?
That's precisely what I want to talk about, Mr. Chairman. Mr. Chairman, we're talking something about an acting one going off and someone else acting in their place. Now the director's off on vacation. Who's acting in his place? Mr. McLaughlin?
Yes, sir.
Well, oh, you are?
Yes, sir.
Well, you have the same responsibility, fiduciary and otherwise.
Yes, sir.
That he does whilst he's there. And he has to put up with what you do until he gets back, whether it's right or wrong.
Yes, sir.
No, you have the responsibility, I think, to retrieve that letter. No one else has that, sir.
Yes, sir. As Mr. Bothwell, if the request is approved, he will be glad to go and
Thank you. It's
look through
approved.
the files.
Can I just ask one question, Mr. Chairman? Did I understand Mr. McLaughlin correct to say that he's acting currently as a director?
The CEO.
CEO?
Yes, ma'am.
Chief Executive Officer, yeah.
And there's a substantive CEO appointed?
Yes, Mr. Albert Anderson.
So is it committed then to believe that you're acting and he's gone on vacation and hasn't left a key for the office for you to act in that office?
He's away on a business conference, and he'll be back Wednesday.
But he's still away. What is the company policy when one officer goes on vacation as far as access to that officer's information? Because it's not, the position isn't personal to holder. It's a statutory body. So it doesn't matter who the person is, he or she, or at least it shouldn't matter. So I just want to understand how that transition is, because I think that would clear some of
Yeah.
what Mr. McLean was saying. And I can't understand why we're asking Mr. Bothwell to go accept your devolving that power for him to go, which then gives a question as to what type of security and access is going on there.
Mr. Chairman, ma'am, in that short period, I have every right to go and open the current CEO's office, but my position requires me to act from my office. I have a substantive position as well as acting CEO, and we do have the keys to every office. The security manager maintains them in a safe. So it is a very secure environment, and it was easier for me to act from my office. But he has gone to open the CEO office and retrieve what it is the assembly has asked for.
Bear in mind, I do ask that we in the process of to give evidence here.
Mr. Chairman.
Mr. McLean?
Yes, sir. Mr. Chairman, I'm not going to try and counter Mr. McLaughlin's position, but I believe in some ways he's wrong. The responsibility, other than the personal correspondence for the CEO, becomes the responsibility of the acting CEO, as long as he is in that position and being paid to act in that position. Nothing is private in there or for the director's eyes only. And if that's the case, then it is for the acting director eyes as well, because it's the position they fill at different times. And it is the acting director's responsibility.
Agreed. I have access to the office. I choose not to occupy that particular office. I am working out of my normal office for the 7 days that the CEO is away.
Oh, okay, I think what is causing this then, what I believe Ms. O'Connor and myself are saying, you need to retrieve it. But if you have chosen to give that to your security officer, he will then have to go and retrieve that information.
Yes, sir.
Keeping in mind that you have devolved some of your responsibility and anything can happen.
He is also the Freedom of Information manager at the time.
It doesn't matter. This is personal, this is files for the CEO that he has no access to, other than he is told to do it, and you have taken that responsibility to send someone else into the office of the director.
Yes, sir. The whole reason why
Okay.
it was started, Mr. Chairman, is it's a part of a Freedom of Information request, so he should have had the files if he deals with the Freedom of Information. So I'm comfortable in my decision to appoint Mr. Bothwell. I understand the ramifications.
Thank you. Mr. Miller?
Thank you.
If I could ask a different question while we're waiting on this letter. Could the minister or the board chairman say what this whole exercise has cost in dollars? The question I'm asking is, what did this whole scenario, the acting CEO discipline an employee, another acting CEO asking for an investigation, that investigator determining that the employee should be reinstated, the first acting CEO is suspended and is retired. What did this whole thing cost in dollars to the Civil Aviation Authority, including early retirement or whatever else was imposed or requested by the first of the three acting CEOs?
We would have to make a calculation on that, Mr. Miller. I really don't know, but we could take an undertaking to try to put a dollar value to it.
Are there any further questions?
Mr. Chairman, through you, sir, we are on the phone to our lawyer, who is Richard Conley, who has given us, he's talking to the minister now about the request that's being made, and he is advising us on a course of action that we should take,
Okay.
so that we don't breach the law. We're not bringing him in here.
Could be a minister got it. Could be the governor got it. Could be the Prince of England got it.
Mr. Nixon, I think a non-disclosure agreement might be exempt from disclosure here, but I don't think that it would apply to just a general piece of correspondence advising the authority on an administrative matter. But at the end of the day, I don't think anyone can physically force you all, but it would then be a matter of your lawyer advice, and then should anyone here decide to move a motion, it becomes that type of an issue.
Right.
Yeah. Yeah. At this time, we'll take another. We'll suspend proceedings for another couple minutes until we've had time to consult the necessary authorities on this matter.